Everyone needs a power of attorney. If you don't have one and suddenly you can't make decisions for yourself, then your family would need to go through a very complicated, very long and expensive process. But a power of attorney is also incredibly dangerous. So you need one and you need to get it right. Let's get into it. Let's start with the basics. A power of attorney designates an agent to manage the financial affairs of the principal. The agent can also be called the attorney in fact. The agent really stands in the shoes of the principal, signing documents as them. So why should you have a power of attorney? Because if you become incapacitated, you need someone else to manage your finances for you. The problem is that once you're incapacitated, then you cannot give that power to somebody else so that they can manage your finances. So you really need to do it before you lose capacity. If you became incapacitated and you did not have a power of attorney, then your family would have to go through a process called guardianship. This process is very long, very time consuming, and it can be very expensive if you have an attorney. It can take several months, if not longer, and it could cost several $1,000s if you're hiring an attorney. So having a power of attorney can save your family time, money, conflict. What could go wrong? A POA is incredibly dangerous. The agent could steal all your money and there might be nothing that can be done to get the money back. Does that mean that you shouldn't have a power of attorney? No. It means that you need to be careful. The most important thing you need to decide is who will be your agent. It needs to be someone who will do what's good for you, not what's good for themselves, especially when no one is looking. Because when it really matters, no one will be looking. Think about it like this. Imagine that you want to cook a soup. You need to cut vegetables, but the knife is sharp. You could really get hurt. So, should you not cook soup? No. It means that you need to be careful. We've walked through why you need a power of attorney, and we've talked about the dangers of a power of attorney. Now, let's talk about some of the options you have when creating the power of attorney. For estate planning, which is what we're talking about here, the best practice is to have a general power of attorney that is effective immediately. If you want to deviate from that, I recommend talking to a mentor. So let's look at the Maryland statutory powers of attorney. So there's a statutory general power of attorney and a statutory limited power of attorney. The statutory forms have additional protections that non-statutory powers of attorney aren't going to have. So if you feel the need to write a power of attorney that's not a statutory form, then usually you would pair that with a statutory power of attorney. That way you have those extra protections if you need them. So in estate planning, usually we're talking about the general power of attorney because you're planning for a situation that you cannot anticipate. And so your agent is going to need very broad powers when dealing with this unanticipated circumstance. So they're going to get powers over everything, essentially, that the principal would be able to do. They'd get the power to manage real estate or sell stocks or manage your retirement account or lodge lawsuits on your behalf. Their powers really go on and on and on in the statutory form because you're giving up so much power. Again, this is a very dangerous document, and so you need to be careful. The next thing you're going to have to decide is whether or not your agent should have the power to give away your assets. And if so, what restrictions they might have on that power. If they do have gift-giving power, then this gives them the ability to strategically give away your assets so that you can qualify for Medicaid. Medicaid planning is an incredibly complicated subject. The downside is that you're giving the agent even more power, which means the power of attorney is even more dangerous. But taking it back to our cooking analogy, sometimes the best knife is the sharpest knife. Even though it's more dangerous, it's better at doing its job. Another option is deciding whether or not to put an expiration date on your power of attorney. There are drawbacks either way. Ideally, you should update your power of attorney every 5 years, just to make sure it still reflects your wishes. Assuming you actually do that, then putting an expiration date on the power of attorney can be a way to limit the danger of it without adverse consequences. But you should be realistic with yourself. Are you definitely going to get a new power of attorney before the old one expires? Because if the power of attorney expires and then you become incapacitated, then it didn't do you any good. One thing to keep in mind is that once you've given out your power of attorney to your agent, it can be very hard to get back. Generally, a copy of the power of attorney is just as effective as the original. So even if you were able to recover the original from your agent, you have no way of knowing whether there's a copy floating around there somewhere. If you change your mind about who should be your agent under your power of attorney, you can revoke it by sending them written notice of revocation. Make sure to also send a notice to your bank or other financial institutions so that they can know not to accept the power of attorney that you've revoked. But if your power of attorney has no expiration date and you no longer trust your agent, then there is always going to be some risk that they're going to use it against you if they still have it. So it could be helpful to have an expiration date on your power of attorney, but if you do, make sure you execute a new one before the old one expires. Next, you're going to have to decide whether you want your power of attorney to be effective immediately or springing, which means that it only becomes effective upon a certain event occurring. Usually, a doctor certifying that you're incapacitated. You only want your agent to use the power of attorney once you're incapacitated, so why make it effective immediately? Most estate planning attorneys agree that making the power of attorney effective immediately is better because, as a practical matter, it can be very difficult to get the doctor to sign something saying that you're incapacitated. Even if someone needs to manage your finances today, it could take weeks or longer to get the right doctor to sign the right papers. That way, the power of attorney is effective. Of course, making the power of attorney effective immediately gives the agent the power to abuse the power of attorney even while you're not incapacitated. But if you don't trust them to manage your finances honestly while you're well and healthy, then you definitely don't want them to have the power over your assets while you're incapacitated. The main problem is picking the right agent. So, what should you look for when you're trying to pick who should be your agent under your power of attorney? The most important thing in picking an agent is picking someone who is trustworthy. Not simply someone that you trust, but someone who has earned your trust. You need someone who's going to be loyal to you, someone who's going to use your assets for your good, not their good. You should think about whether or not this person has any reason to take your assets for their own. Maybe they have a drug problem or gambling problem. Those would be things that would not make a good agent. You should think about whether or not this person manages finances well. Do they manage their own finances well? That'll give you an idea of whether or not they'd be a good fit for managing your finances. Now that we've talked about some of the options you have when making your power of attorney, we'll just talk about some of the technical details and then some suggestions. So first, in Maryland, a power of attorney has to be written, signed by the principal, notarized, and witnessed by two people. And the notary can be one of those witnesses. It can be a good idea to execute multiple original power of attorneys. So you could execute two for every client and then one more for every piece of real estate that that person owns. Because when you're transferring real estate through a power of attorney, often they're going to require an original power of attorney to be filed with the court. You'll get it back, but the recording process can take quite a while. And so if you're transferring a lot of assets, then you don't want your only power of attorney to get tied up for several months before you can move on. So having multiples can be helpful in that regard. Another thing you can do is to go to your bank or financial institution and file your power of attorney with them. This can make it easier for the agent when they're going to need to use it. Another practical strategy might be to keep your power of attorney with your important papers. Tell your agent where it is, but not give it to them. That way, your agent can still get to it when they need it, but if you change your mind and want to revoke it, it's still in your possession, so it's very easy to do. So let's recap. So you need a power of attorney, but it is dangerous. So you need to pick someone who's going to act in your best interest, not their own. You need a general power of attorney, probably with gift-giving powers, probably effective immediately, and maybe with an expiration date. Thanks for watching. I'll see you next time.